I'd like to entertain a motion to open the ZBA meeting.
I make a motion, we open.
I'll second that. All those in favor by aye?
Aye.
Aye.
Okay. Okay, first item. The approval of the December 9th minutes. Where did they go? Here they are. Has everybody had a chance to look at the minutes?
Yes.
Yes.
Anybody have any comments?
Nope.
Okay, I have two things that I would ask. There is one line in there. It says Chair Loza mentions a public comment that was submitted related to this application and reads, you have a letter into the record. Please change that to part of a record.
Part of a record?
Yes, part of the record. I didn't read the entire letter.
Oh, okay.
On the next page, it says Moriello chimes in to explain that the zoning board role is fairly narrow here.
Mm-hmm.
I would ask that you take out the word chimes into and add an S at the end of the word explains. So it reads, Attorney Moriello explains that the zoning board role is fairly narrow here.
Okay. You don't like the word chimes?
Not appropriate.
I'm a creative writer, Len.
I understand. Okay.
No objection, Len.
Thank you. And then 2 lines below it, it says whether a trail is ever located on the property or no, put a T at the end of the word, not.
Okay.
Okay? Anybody else have any other changes to the minutes?
Is it too much to be pedantic about spelling?
Well, it should be
No,
correct.
I can correct them.
Somewhere in there you say per se, and say is SE.
Okay.
Alana,
Yes.
it might be easier if we put numbers on the pages, only because it would be easier for you to find things if in fact we needed to help direct you.
Okay.
Okay, thank you. Okay, any more
Len,
comments? Joe?
if I can just jump in, I realize it's a video Zoom meeting, but maybe for the written record, we should take attendance.
Yes, we're going to do that.
Okay.
Do you want to approve the minutes contingent upon my making those changes?
Yes, that's what I'm going to say.
Oh.
I entertain a motion to approve the minutes as amended.
So moved.
I second.
All those in favor by aye?
Aye.
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 Okay, let's take attendance. Leonard Loza's here. Steve Esposito,
Yep.
he's here.
Yes.
Amy Donnelly is here.
Yes.
John Gatto is here.
Yes.
Is Catherine Fuller here?
No, she sent an email that she couldn't make it.
I did receive that email, but she said she might come, but I thought I would ask anyway. Okay. Next item, quorum check for Wednesday, February 10th. I'll be available. Steve?
Yes.
Amy?
Yes, I'm not going anywhere.
Okay. John?
Yes.
Okay, thank you. And I can't speak for Catherine. Okay, at this particular point in time, I'd like to open the meeting for public comments. If you do wish to speak, please state your name and where you live.
Hi, it's Kitty Brown. I live on Rocky Hill Road in New Paltz.
Thank you.
Shall I begin?
Sure, begin.
Okay. Just FYI, we had a huge pipe burst in our house today and we are still cleaning up. So if
No.
I seem a little discombobulated, that's why. So I just want to highlight the information I sent you all last week. I don't know if you had a chance to look at it, but I
I
think
did.
the premise that you are being asked to vote on is based on a misunderstanding of both the purpose of buffers and the Empire State Trail. And I can't do a better job of explaining the essential service that buffers provide than ENCB Chair Hickle, who will talk to you later. But I do want to stress that the mission of the 750-mile Empire State Trail is that it weaves together pre-existing transportation corridors with the intent of welcoming visitors to experience local urban centers, village main streets, rural communities, and it encourages healthy lifestyles, supports community vitality, and bolsters tourism-related economic development. To my knowledge, the entire trail is constructed on or adjacent to previously existing transportation corridors or trails. I am not aware of any section of the trail that bulldozed forests, farmland, buffers, or any undisturbed vegetated areas. The commercial site known as CVS Trans Hudson is perfectly sited to meet all of these goals without disturbing the buffer. There are no hardship obstacles. People will be entering from the paved Route 299 corridor and exiting onto the paved new North Putt Corners Road corridor. The parking lot will already be paved, and all it will take is to erect some guardrails to make this connector trail an economic boon to the developer and to our town. Please overturn the building inspector's decision and let the Empire State Trail connector trail proceed without a waiver. Thank you.
Thank you. Does anyone else wish to speak?
Are you taking comments now on the Kushner application on Cedar Ridge, or are you going
No.
to?
No, that will be a little bit later.
Okay, thank you.
I have a comment. Is that okay? Can I proceed?
You may state your name, please, and where you live.
Of course. Good evening, everyone. My name is Daniel Schneeven. I live in the town of New Paltz. Just going to read a very brief letter. Dear members of the Zoning Board of Appeals, I'm writing with a few brief points following the building inspector's January 7th letter to the ZBA concerning the throughway buffer at the Trans Hudson site. I want to thank the building inspector for taking the time to write the second letter, which was very helpful in clarifying her original interpretation. I also want to thank all of you for your careful deliberation on this matter. I appreciate the building inspector's sensitivity to the role of the planning board in this process, as well as her desire not to interfere with their ability to do a full review of the various aspects of Trans Hudson's application. Nonetheless, I think the code is clear, calling for a quote, substantial vegetated natural buffer, quote, with a minimum depth of 30 feet. While the town board passed this zoning provision, we have not heard from them directly. The chairperson of the entity that crafted this portion of the zoning, which was the town of New Paltz's Route 299 Gateway Committee, wrote in a public letter to the town in October, quote, please note this buffer was intended to be free of improvements and disturbance, end quote. Clearing and paving nearly half of the buffer would be contrary to both the word and spirit of the code and should be prohibited. This is a determination that the ZBA can make at its meeting tonight without breaching the jurisdiction of the planning board. All professional literature on this topic, including the article from Applied Acoustics cited first by the ENCB and then by the building inspector in her January 7th letter, indicates that the deeper the vegetated buffer, the more effective the noise mitigation. This is why the code calls for a baseline of 30 feet of vegetation, but imposes no maximum. The 30 feet is provided as a minimum standard, not a starting point that can then be whittled away. There's no question that a 16-foot buffer, which is to say the 30 feet minus the 14 feet for the Empire State Trail as proposed, would provide some noise mitigation. It would. However, it seems plainly apparent that this would be less than what the code seeks to require. It's worth reminding ZBA members in closing that the Gateway District zoning in question here was the result of a long-term process that involved substantial community participation and many, many volunteer hours. While I was not among those who helped formulate the Gateway District zoning, I was among many others who encouraged the town board to adopt it, which they did unanimously in October 2019. Given the public's investment in this portion of the code, it would be a shame for it to be so significantly compromised in its first application. Fortunately, the applicant has plenty of room on the site such that they can shift the Empire State Trail out of the protected buffer without sacrificing the possibility of a successful project. I hope the ZBA will vote to stand by the code as it is written and determine that such a major reduction of the buffer is prohibited. Thank you very much.
Does anyone else wish to speak?
Len, Ari Freilich had his hand up.
Okay. I didn't see a hand up, but go ahead if you'd like to speak.
It's our contention that the
Excuse me, your name, please, and where do you live?
Ari Freilich, I currently live across the river in Clinton Corners, Dutchess County. It's our contention that the zoning code provides ample, clear language that would have enabled a clear understanding that paving within this buffer area is prohibited. They chose to not use the term buffer strip, which excludes all paved areas, but instead used an alternate term, which does not. We do not, we rely on our attorney's full-fledged argument on this point, but I want to emphasize that there is a language matters and there were choices that were made and expressions, hearsay expressions of what the intent was simply cannot be used to contravene the obvious and plain intention of the language. I'd like to remind everybody about something else. We support the building inspector's opinion, which essentially, as I read it, gives to this board a fair amount of discretion in this topic. As I understand it, the building inspector said there's nothing that precludes the bike trail running through this, but rather that it was a matter of some discretion. What occurred here historically is this. We were approached by various representatives of New Paltz who asked us to improve the bike trail by locating it within our property. And we were amenable to do that. The issue is, contrary to what Daniel suggests, this does have a meaningful, oh good, I just lost my screen. It does have a meaningful impact upon our ability to develop it. It's a tight site. We're trying our best to adhere to all the zoning requirements, and it's a tight site for us to put together a rentable real estate. We do not have the ability to accomplish what we need to accomplish to make this viable and to move the bike trail out of the 30-foot buffer. We fully intend to plant it heavily. We will continue to have a green zone with whatever sound blocking and other environmental benefits that brings. But I want to remind everybody on the board that it was the town that came to us and asked us to do this. This is not something that we have to do. It's something that we're trying to be helpful and therefore to give to the town. We're not charging anybody for it. We're not offering to sell it or assessing any fees to this. We're simply saying we're happy to provide it. We'll goose up the planting, we'll improve what we need to do, but the way this appears from our perspective is that we're trying to be good neighbors, we're trying to do the right thing, and we're being told, well, we don't want your gift. And so perhaps perhaps this is not such a critical location from your all perspective. Perhaps it's something that someone should step forward and say it really isn't that important to us, because we've certainly have spent a great deal of time and heartache and money trying to satisfy this request. And that's what I have to say.
Thank you. Is there anyone else who would like to speak? Alana, do you see anyone else waiting?
No, I don't see anyone else with their hand up. I don't have any comments on YouTube.
Okay. So I entertain a motion to close the public comment at this particular point in time.
I second it.
Thank you. All those in favor by aye?
Aye.
Aye. Okay, public comments. The first item on the agenda for public hearings is 16 Cedar Road. Mariana Kushner, are you there?
Yes, I'm here. How are you?
Is there any chance you could rotate your screen 90 degrees?
Yep.
There you go. Thank you.
Actually didn't realize I was upside down.
Okay. We have heard what you wanted to do at the last introduction, but just for the purpose, if we may have some new members signed on and listening, could you please explain to us again at what you would like to do?
So basically, I want to construct a fence. I actually started constructing it because I have a permit for the permitted height, which is up to 6 foot on the sideline, side lot, and up to 4 feet in the front yard as defined in the code. And basically that height is not sufficient to block the view of the deteriorating condition of the property at my neighbors, which is 14 Cedar Ridge Road. You know, it's been quite some time since myself and also other neighbors on the block have tried to bring attention to the town of the issues that we have with the neighbor, as we are surrounded, as we are neighboring the property that's deteriorating, and we believe it's putting, for me personally, it's deteriorating my quality of life since I have to look at his basically junkyard daily out of my living room, and I basically got sick and tired of that. And there was nothing that was enforced, or nothing that the town was able to enforce, despite you know, complaints spanning now over a year. And so that was basically the last, the only possible option that I have is to block that view. And if you reviewed my application, actually it was pretty thorough with my application, and I submitted a bunch of photos. If you can see that the landscaping is such that my property is a little bit kind of like down slope. So as you can imagine, as you can imagine, that if you have this kind of landscape, that an object that's up the hill right, will appear even larger if I'm down the hill. So that's why that height is important for me to block the view. It's the garbage, and also, well, I consider it garbage, but he's in the process of constructing sheds. There's absolutely no architectural or aesthetic consideration to those. And again, being the neighbor to 14 Cedar Ridge Road for some time, I can attest, and as my neighbors can attest, the projects that get started, they do not get finished, and the refuse and junk keeps accumulating. And there were a number of letters sent in support of this application from my neighbors, and those letters discuss exactly the same issues that I'm referring to. So that's a brief situation overview.
Go back down to reactions.
Excuse me? Sorry, I thought someone has a question.
It may have been somebody who failed to mute their mic.
Okay.
I saw your application. I went by the property. I looked at your photos and the neighbors' comments. I thought that was very clear. Thank you.
Mm-hmm.
Hello, we are at 12 Cedar Ridge Road. And I also wanted to mention that we totally agree with
your position.
We're on the other side, and it is an abomination. It is horrible. Okay? Thank you.
Thanks.
Okay, thank you. Is there anyone else that would like to speak?
Yes, I would like to speak. My name is Avram Siegel. I'm at 21 Cedar Ridge Road. I sent the board members a rather extensive letter with zoning code sections. It is clear to me and to my neighbors, at least, if you look at any one of those sections, that the code officer, the code enforcement officer, has the right to have or to lodge a complaint against the property owner at 14. As I mentioned in my letter, and it's unfortunate that Ms. Kushner has had to resort to building a fence when a simple request, which she has made, I believe, to the property owner on several occasions, would resolve the matter. Instead, she's had to build this fence, and while it's discretionary with the code enforcement officer, I pointed out to the board that it has been 2 years, a little over 2 years now, since I first wrote to then Mr. Jaffe, who was the code enforcement officer, who was then succeeded by Ms. Della Reed. And also, I don't believe she's any longer with the code enforcement division, a Ms. Granieri, who visited this site as well. We are all cognizant of the fact that we're in the middle of a pandemic now, but I really think that it's inexcusable that 2 years have elapsed and no action whatsoever has been taken with respect to this property owner. And as my other neighbors have mentioned, and when we moved on this block 6 years ago, I bumped into somebody who in the village and was speaking, and he asked, "Where do you live?" And I said, "Well, we live on Cedar Ridge Road." He says, "That's one of the nicest streets in the town." Not anymore. Unfortunately, we have this neighbor, another neighbor whose issue we'll discuss another day, but I really think it's incumbent upon the board to give Ms. Kushner the relief that she's seeking, but also, as Ms. Della Reed is, I believe, present or should be present, I know she was copied on the letters, to exert some pressure to get this done. Whether or not the municipal court would enforce the various provisions that I've cited is undetermined. But I think that this particular property owner and another on the block have really gamed the situation by telling the various code enforcement officers, yes, I'm going to take care of it. I have an email file from Mr. Jaffe, who spoke with the gentleman and was promised that it was going to be cleaned up because he was, and this was 2 years ago, he was in the process of selling the property, which in fact he wasn't, but it didn't sell. And the situation, the photos that I attached are an example of what the property looks like, not only now, but then. The large trailer that's there, nothing has moved. It is waste, it is refuse, it is rubbish. It falls within the confines of the town ordinances. And I believe that unfortunately, as I said earlier, Ms. Kushner has to build a fence in order to have the quiet enjoyment of her property, which she is legally entitled to. Thank you.
Thank you. Is there anyone else that would like to speak hearing for 16 Cedar Ridge Road?
I also want to mention, I know that the letter was sent from my neighbor Eileen. It was maybe slightly past the deadline that you guys asked, which was at 12 p.m. But I'm sure, Alana, you've probably seen that letter that came through. So I don't know how strict your protocols are for admitting those letters. The letter was from Eileen Faulkner. So she's at 17 Cedar Ridge. She's literally across the street from 14 Cedar Ridge. So we had a conversation. She's very upset on the view that she has to look out on the window of her window. Obviously, she's not as close, but it's almost like, all right, so what is her remedy? Also build a fence. And so, you know, like at this point, I'm out $7,000 and $500 to the fees for the applications. However, the neighbor next door just, you know, his actions are unpunished, and I think that's unacceptable.
Okay, thank you for that comment. Is there anyone else that would like to speak?
Yes, I would.
Your name, please?
Thomas Kakandis. I'm the owner of 14 Cedar Ridge Road, who seems to be, interestingly, the main subject of this discussion this evening. I submitted a letter in support of Ms. Kushner's application, thinking that was a gracious thing to do. I didn't realize that so much of the meeting would be taken up with trashing my property and lodging complaints. Outside of Ms. Kushner, none of my other neighbors have seen fit to address me directly or even copy me on any of their submissions to the town of New Paltz, which understandably is quite upsetting. Of course, the Sloans are not mentioning that I suffered nearly $20,000 worth of damages from their underground oil storage tank, which took away from my ability to improve my property. Nonetheless, I've steadily improved the property. I did have the property for sale. I did have an inspection by the building inspector. She can speak to those results. There is no garbage. There is nothing rotting on the property. That is not clean wood. And I'm very dismayed to see that the attention of the board is being directed not to the topic at hand, which is Ms. Kushner's, again, I support it, reasonable request to have a slightly higher fence based on the difference in elevation. The history of the property is that Ms. Kushner bought a building that was placed 20 feet from my property and built with large windows only facing my property. That's not her fault. She was not the original constructor of the building. She has 1.36 acres. And in the past disputed the property line. I applaud Ms. Kushner's expense and effort to educate herself on the actual property line and to place the fence properly. So thank you for that. However, what is this about? We've had an inspection. The allegations that have been made have been shown to be outside of the code, and there is nothing in the town code that means that says that I can't have a trailer. This is not a residential trailer. This is an over-the-road trailer for carrying things on my property. So I'm sorry that my neighbors are ignorant of those facts or choose to ignore them in their comments. Rather than get involved in defending myself further, I just thought it was worth noting that I support the application. And further, I had explained to Ms. Kushner directly and verbally that one of my remedies to her incessant complaints, baseless complaints, including the side lot assertions that I had changed the markers on the side lot, which are patently false. And she has since, I presume, satisfied herself that her understanding was a misunderstanding and that my survey was reinforced by her own survey efforts. Great, let's move past that. I'm continuing to improve my property. I'm screening my use, my legal use of my property with sheds that are duly permitted. This is a matter of record that the building inspector can verify to your satisfaction. I do not appreciate being trashed in this public forum, and I do not appreciate complaints being lodged with the town and not shared with me. That is in essence an act of bad faith. Thanks very much.
Thank you very much. Is there anyone else that would like to speak? Jen? At this public?
I just wanted to notice that I never disputed Mr. Kakanda's property, and I never claimed his property. And I think lodging complaint via town would going directly, that's the venue. And since I don't understand what the issue is, that we are not required to CC who we complain about. And since the communication have broken down a while back, I don't think we owed neither, either Eileen or Avram or Sloan's, they do not owe to CC everyone who's, in our opinion, offending the code. It's okay, you disagree, but we do not owe to CC you, Tom, what we complain about. We have made an attempts in the past to explain our view, but you didn't share that view.
Okay, thank you. Any other comments? Joe? Stacy? Alana?
Yeah, I don't see I'm not seeing anything else unless someone can't unmute themselves. You can raise your hand, but I don't see
Okay.
anybody.
Alana, can you please add something to the attendance?
Yes.
I forgot to include Joe and Stacy.
Oh yeah, no, yeah, they're there. No worries.
I know they're there, but I just wanted to announce that, okay?
Okay.
All right. At this point in time, I'd like to entertain a motion to close the public hearing for 16 Cedar Ridge Road.
I make a motion to close it.
I'll second. All those in favor by aye?
Aye.
Aye. Okay. Next is a public hearing for 139 State Route 208. Mr. Rotolo, are you there?
Yes, sir, I am.
Okay. I'd entertain a motion to open that public hearing, please.
Move.
Lynn,
Joe?
before we open the public hearing, I'd just like to hear from Alana as to whether or not all of the procedural steps regarding the public notice have been taken, and do we have a record of them so that you can open the public hearing?
Is there an affidavit in presence, Alana?
No.
There is not. So as the fact that there is no affidavit in process, am I correct, Mr. Moriello, that we cannot open a public hearing because we know that we don't know if the neighbors have been duly notified?
I'd be concerned about that. I mean, unless the applicant, who apparently is on the line, can tell us that the steps have been completed, and it's just a matter that maybe the paperwork hasn't reached the ZBA's secretary yet.
No, sir, that is not the case. I did not complete those things because there was we're beyond the statute of limitation. 274B6 says that we have 62 days from the date of when an application is received to conduct a public hearing. And there was also two errors, significant errors on the legal notice that made it impossible to go forward with that hearing. I would like to get on the record what those two errors were, if I may.
If the applicant thinks there were errors, I think the board can hear it.
I would like to hear them, please.
Okay. On the legal notice, it says that I'm trying to operate a multifamily in an area where there are allowed only one-family homes. The email from Stacy Deladere that is dated the 2nd of December says there are a few pre-existing non-conforming parentheses constructed or converted with C of Os prior to 1976, close parentheses, multiple dwellings located within the R1 zone. So it is not accurate on the legal notice to say that I am trying to operate a multifamily in an area where only one-family homes are allowed. As a matter of fact, right across the street from me at 136 and 138 is my neighbor who has two houses on one lot. And I had received a notice from Mark Jaffe saying, yes, that's because his were built before 1976. So that the first error on the legal notice is the fact that it says in an area where only single family homes are allowed. The second area is on the legal notice. It doesn't mention anything that I have said in the event that the board does not approve the multifamily, which I understand based on what's on the line, and I know that on the online information, I know that Mr. Moriello said, well, that was an error posted by the company that we hired, so I accept that. But I said in the alternative that that's not approved, then I'm requesting permission to operate in a manner that is consistent with the way the Ulster County Board of Health has previously approved me to operate. So the way the legal notice was written, it was written in such a way that it left out important information, and I did not. And in addition to the 274-6, which says that the time period within which to conduct a public hearing on a special use permit is 62 days. All of that taken together. And I believe that I have sent in information to that effect. So that is the reason why I did not complete because we are beyond the statute of limitation primarily, and the legal notice is effective. That's it.
Okay, Joe, do you want to comment on that, or would you like me to say something?
Well, I see Amy had her hand raised.
Yeah,
Realizing that there's no public hearing been opened yet.
Yeah, that is correct.
questions don't pertain to that, but when we have a completed application, when we have an application, I would like to ask, if it's appropriate, that any conversations with Mark Jaffe, Mr. Rotolo refers frequently to things that Mark Jaffe told him or allowed him to do, that those be documented in writing. I haven't had any contact with Mark Jaffe. I'm a new member of the board. I think I need that information, written information, not Mr. Daffy allowed me to do. We had a verbal agreement before I would consider. And another question is, does the 62-day clock start after a completed application is set and a public hearing is held? Mr. Moriello, does the 62-day clock start after the public hearing is closed?
There's a provision for the board to make a decision within 62 days following the close of the public hearing.
That's the clock I refer to, sorry.
And we're not at that stage yet because the public hearing has yet to be opened, let alone closed.
Yes, thank you.
Yeah. And even if, well, I understand that there is some argument on behalf of the applicant regarding the setting of the public hearing, not complying with that statute. Certainly is the applicant's prerogative to make such an argument from a legal standpoint. I disagree with it. Under the totality of circumstances in this particular case, and even if that were to be so, there is no automatic approval of an application that necessarily follows under the statute or by case law. I think it's my position or my advice to the board that under all of the circumstances that have happened with respect to this application, that the public hearing was timely set by the board at its meeting in December to occur at this meeting in January, which is well within the 60-day limit imposed by the statute. That's my advice. And if this should meet some judicial challenge, that will also be our position on behalf of the Zoning Board of Appeals. I think the setting of the hearing was timely. I'm concerned that the public notice was not concluded by the applicant. This is the applicant's application. The notice of public hearing is determined and set by the Zoning Board of Appeals. I realize the applicant may disagree with its content. And if that's the reason why he has failed to give the proper public notice and signage, etc., he's privileged to take that position, I suppose. I think that it's fatal to the application, but he's privileged to disagree. We've not had occasion where an applicant who's seeking relief has failed or refused to give the proper notice so that all of these issues can come on to be heard at a public hearing before the board and aired, including the applicant's position, pro or con, whatever his or her arguments may be. So I guess I would ask the applicant if he intends to complete that process so that the public hearing can be opened and proceed, or does he intend not to do it and stand on some other legal principle at this point? And it's a question I think that only the applicant can answer.
Well, it's,
May
you may speak.
I please read into the record 274B6? Is that a yes?
You know,
Yes.
Here's my problem. Taking proof on this issue, if you will, is not occurring at a public hearing. Mr. Attolo, the problem is you want to make these arguments before the board actually has jurisdiction to entertain the issues that you raise. You can read it, but I mean, I'm well aware of the section and what it says.
Okay, I would like to read it
But I
into the
really,
record.
I think if you want your application to proceed, the board needs to proceed at a public hearing.
Well, the
Okay.
application can't proceed based on the fact that the affidavit that the applicant has done what they were supposed to do did.
I don't see how it can in other circumstances where that has occurred. Sometimes maybe because an applicant wasn't able to complete it within the time, or there were some other intervening factors. The board has generally continued the matter until the applicant can complete it. And I think that that's fair and reasonable if that's the request. My question is whether or not the applicant intends to complete the process at all.
The on a non-flawed legal notice, a legal notice that is consistent with omitting the errors that I pointed out, and on that issue, yes. However, I still have the issue that I would like to read into the record what 274B6 says, and I don't know how to get around this, because applying the plain meaning of the words 274B6, and I have a date stamped completed application that was issued in 2019. I mean, this application has been around a while, but anyway, if I may, I would like to read into the record 274B6. Public hearing and decision on special use permits, period. The authorized board shall conduct a public hearing within 62 days from the day an application is received on any matter referred to it under this section. That application, I believe, is dated November 2019, and it is a completed application. And I have a date stamped application that I submitted on or about November 19, 2019. I don't know how to get around this statute of limitation issue. Now we can redefine it, but the problem with the statute of limitation to me is insurmountable. The problem with the legal notice, I suppose it can be fixed to read something like, the applicant is requesting a permit to be allowed to operate as a multifamily residence consistent with property of 136, 138, and other properties in the R1 district, or in the alternative, to operate in a manner as approved by the Board of Health previously. Something along those lines would fix the legal notice.
Mr.
But
Rotolo,
I still don't. Yes.
Mr. Rotolo, the
Yes.
Board of Health does not determine what the uses are in the particular zones. The zoning codes in the town of New Paltz make those decisions. Your application was submitted on the 19th. Running along quickly, you ended up going to court. You spent time in jail. You later decided that you did not want to attend any of the Zoom meetings, that you wanted to do an in-person interview. A large amount of
anything
time.
that is under appeal, sir. Anything that is under
A
appeal.
large amount of time elapsed, and now you come to us to tell us that the 62-day clock is ticking. Your application is not completed based on the fact that you have not completed all the obligations. You have not supplied the necessary documentation for the public notices. It's plain and simple. You received that information from our secretary, and you chose not to provide that information. I will offer you a continuance of this public hearing to the February 10th meeting if you would like. We will take a motion. We will take a vote with that, but we are not going to continue on with this and listen until you have provided the appropriate information as dictated, as told to us by our attorney. I'm asking for a continuance of this meeting, for the public hearing.
Are you asking me or the members of the zoning board? I'm sorry?
I'm asking for a second from a zoning board of appeals member.
Len, I would like to ask a question. Is this a use variance, an area variance, or a special permit? I don't want to continue a hearing. It sounds like Mr. Rutolo is asking for something different from what he asked for previously.
Stacy?
I think Joe was just going to say something, so let Joe respond as your counsel first.
In answer to Amy's question, and if it'll help the members of the board, the application before the board at the present time is for the issuance of a special use permit. It is not an application for an area variance. It is not an application for a use variance. It is an application for a special use permit to allow what is essentially, as submitted in the public hearing notice, a multi-residential use within an R1 zoning district to be allowed by special use permit. I have sent to the board members and Mr. Rutolo is in receipt of it, a letter when this application came on to be heard in December that there is no provision in our existing zoning code which allows for the issuance of a special use permit within an R1 zone to permit the use requested. Mr. Rutolo disagrees. Earlier, he characterized it saying that Moriello said that the company that publishes our code made a mistake. That is not the case. Mr. Rutolo, you know that's not the case. I made copies of the section as it appears in the code. Now, I understand that you looked at something, I assume, online, and somehow were led to believe that this type of use was allowed within the zone. It's the principal reason why I wrote the letter I wrote, to clarify that the official copy of the code does not permit this type of residence within this zone by special use permit, either granted by the Zoning Board of Appeals or by the Planning Board. Neither of those boards, in my legal opinion, has the authority to grant the relief that's being requested. Amy, does that help?
Yes, thank you. That clarifies it completely to me. But if the application is for that Alana would give the applicant is for only an area variance, a use variance, or an interpretation, then Mr. Rotolo can't have filled out or can't fill out in the future a special permit application to come before this board. So perhaps we're just chasing our tails here and we should stop.
But he chose to make an application for a special use permit, notwithstanding, I believe, that he was advised that a special use permit could not be granted by either board. But the applicant chose to submit an application. Quite frankly, from a legal perspective, I actually considered that for that legal reason, the board should not even entertain the application as it did not have jurisdiction to grant the relief. However, under our system, we have a system of due process. People are entitled to notice and to an opportunity to be heard before a municipal board can and should make a decision. For that reason, the board went forward and set it down for a public hearing. It is at that public hearing, in my view, that the applicant is free to make whatever arguments he or she wants to make regarding the granting of the relief. It's my opinion, based upon our research, that the zoning board of appeals can't grant this application, but that's not to be said that in a proper forum, the applicant could present evidence to suggest that I'm incorrect. And that is the type of evidence, if you will, argument, legal writing that goes on at a public hearing so that the board has a complete record comprised of the applicant's position as well as the position of members of the public. So that's why we're engaged in holding a public hearing, at the end of which the relief may or may not be requested, but the applicant and the public are entitled to be heard on the issue, in my view.
That clears
I,
everything up.
I would like to second the motion that was made by the chairman.
Thank you. All those in favor signify by aye.
Aye.
Aye. Amy, are you there?
Did everybody, well,
It
Mr.
appears.
Esposito, you're recusing yourself?
I am, yes.
Okay,
Okay, Stephen is recusing himself.
right, okay.
So we have myself, we have John. Amy, do you vote for a continuance of this public hearing to the February 10th meeting?
Yes, I do. I'm sorry. I was having glitches with my,
No, it's okay. That's okay.
Yeah.
So motion carried, Mr. Rotolo. Your
Yes.
next meeting will be February 10th. Please provide the information that you have been requested. If you are unclear as to what it is, please see the building inspector.
Will do.
Thank you. Okay. That public hearing was never open, so there's nothing to close on it. Okay, we are now at the next item on the agenda with regard to the building inspector's appeal, Route 299, North Putt Corners Road, Grand Hudson. We've heard people speak pro, we've heard people speak con. Joe, comments? Stacy?
I just want to make sure that the record is complete. There was, and maybe we should put it on the record. The board did receive an additional supplemental letter from the building inspector. Am I
That is correct.
Okay.
Has everyone seen that as a clarification letter?
Yes.
Okay.
Has the board or the secretary received anything in addition to that letter from the building inspector?
Yeah, there was a letter from the ENCB following up on her letter.
Okay.
Yes, that is correct.
So the board is satisfied that it's, I lost them.
I'm back.
The board is satisfied that it has received at least what it believes is now the complete submission. I see.
Yes, I have all of the information, the second letter from ENCBN, and I have the January 6th explanation from Stacy Delaree. I guess the first thing we might want to do is ask any of the board members if they have any particular questions with regard to Stacy's letter of clarification.
Yes,
Amy?
I'm good.
Steve?
I'm good.
I do have a question, Len.
Yes, please, Sean.
Yes, Stacy, first, thank you for taking all the time and effort to do this. When I got that second letter, which was meant, I think, to be a clarification of the original conclusion you came to, I followed your reasoning, which was made pretty clear. But in the end, what it looked like to me was not a clarification of your conclusion, but you actually seemed to come to a different conclusion. Your first conclusion was that it would not be prohibited. your second conclusion was that it wouldn't necessarily be prohibited, or meaning that it might be, which in turn means that it might not be. So to me, that's less of a clarification than an actual change. And that confused me somewhat and made my thinking a little murky on the whole thing. Can you comment on that?
Well, when they say that, I mean, that's going to be up to the planning board to make that determination when they do that review.
I understand that.
So there's nothing in the code that prohibits it from being there. Okay.
So that's still your conclusion.
Yes.
Okay.
Joe, do you have any comments?
No, I think if the building inspector, and I see Mr. Lithgow in attendance, if they're satisfied that the matter has been fully submitted, then I think the board, excuse me, if it wishes, can discuss the appeal, the evidence that's been submitted on both sides, whether the board is going to be able to come to a decision this evening or not, I don't know. I would suggest that this may be a decision that the board may want to render a written decision, or at least see some form of written decision based upon maybe your discussions to determine whether or not it wants to adopt that or not, but that's up to the board.
Okay. I'd like to, if I could, run through a few things that I've come up with, and please, if anyone believes that I'm wrong, please jump in. On September 14th of 2020, we received a letter from Stacy Diddlery, the building inspector, concerning the MSMU buffer requirement. Design standard waivers can only be given by the planning board, not by the ZBA. ENCB does not have the authority to interpret the code. They may only advise, of which they have done, and I thank them for that. Whether a trail is to be located on the property or where it will be is really the purview of the planning board. They ultimately, that's for them. We are here to agree or disagree with the building inspector. The buffer strip existed in the code at the time of the gateway discussions. A buffer strip is designed to protect residential uses from activities on the property having that buffer strip. The MSMU buffer is designed to provide visual, noise, and air impacts. A buffer strip is supposed to be 100 feet. A MSU buffer is 30 feet minimum from any property line New York State Thruway. The New York State Empire Trail Group relocation is not opposed to the pathway through the Trans-Hudson property location. Buffer strip does not allow a paved area in the MSMU. A increased vegetation buffer of non-deciduous trees, evergreen trees, will provide year-round protection, which the owner of the property has stated that they will gladly put in place. Those are my thoughts and some opinions that I've gathered from all of the letters that I have read. If I am wrong in any respect, I would really appreciate if someone would correct me.
Len,
And then, yes, John.
I think it's really important to get back to this point about the buffer strip versus the buffer, the MSMU buffer, because I think there's been a lot of very unproductive probing into this language. And it's been stated that if the zoning code wanted to, they could have used a defined term of buffer strip, but they chose not to. And I contend that that they had to use a different terminology because the definition of a buffer strip says that you're protecting the property that has the strip from, you're protecting properties outside that property containing the buffer strip from the activities within. It's very different, and it says so right in the language that sets up the MSMU buffer, that its purpose is to protect that property containing that buffer from the throughway. So all the discussion about buffer versus buffer strip has been very unproductive, I think, and it's very clear to me, at least, what the intention of the code is regarding the buffer in MSMU as it's, I think, very clearly defined. So I would like to lay that whole topic to rest. It's brought more confusion than anything else to this. I think we can continue talking about where we are on this without referring back to the buffer strip discussions.
Okay, thank you. Amy, do you have any comments?
Well, just a question. I thought that what the ZBA was charged with was deciding whether this was a buffer or a buffer strip. That is,
No,
whether we support or don't support Stacy's interpretation.
I don't think that's the question. If it's a buffer or a buffer strip is not our question.
The question is whether Stacy's interpretation is to be upheld or not upheld by the ZBA. That's our only part in this. Is that correct?
That is correct.
Okay.
That's our only part. Stacy, do you have any comments at this point in time? I mean, both in writing.
I do. I have a closing statement for you, but I think that I did see a chat from Ingrid that she was hoping to speak.
It's fine if Stacy would like to go. I just wasn't sure the format. I was hoping to make some comments as well.
Yeah, I wasn't sure of the format either. I just have a closing statement for the board at this time.
Okay, so we'd let Ingrid go. Ingrid,
Okay.
if you'd like to speak.
Thank you. Good evening, everyone. Again, my name is Ingrid Heckel. I'm chair of the Environmental Conservation Board. Thank you to the building inspector, to Stacy, for the time and effort you put into the clarification of your interpretation, which is very helpful. And thank you all for your time in reviewing this appeal. So our appeal really focuses on a narrow question, which is whether the location of a 10-foot paved trail and associated clearing in the MSMU district's substantial vegetated natural buffer, or MSMU buffer, is consistent with or contrary to that buffer requirement, and therefore whether a waiver of that design standard would be necessitated. We believe that the ZBA has the power to interpret the zoning law and make a determination in this case about the meaning of a substantial vegetated natural buffer and whether it is consistent or contrary to put a paved trail through that buffer based on the information in the code describing that buffer, in its basis in the town comprehensive plan, the location of the trail on the conceptual site plan from Trans Hudson, and published design guidelines about the Empire State Trail, which specify that the trail must be a minimum of 10 feet wide and have at least 2 feet wide shoulders on either side of it, which would total a disturbance of 14 feet running through nearly the entire length of this property of that MSMU buffer. So we, the question is really, is putting the trail through that buffer consistent with its purpose and the intent of the comprehensive plan. And we believe that a disturbance of this magnitude is clearly inconsistent with that purpose, and that reducing a buffer that is supposed to be of minimum 30-foot width to 16 feet or less of vegetation even if it's enhanced, is not anywhere near what's called for under the code, and therefore would necessitate a waiver of the design guideline, which it's fully up to the planning board to determine whether they would want to approve a waiver. So I would like to share some images very quickly, if possible, to help us, I think, visualize and understand what 16 feet of vegetation looks like compared to 30 feet of vegetation, and also what 8 feet of vegetation, which is, if the trail is through the middle of that buffer, there would only be 8 feet on either side. So I'm just going to share, I don't know if I can share. I'm not seeing an option to share. Alana?
Should be able to.
Weird.
I haven't changed any of the settings. Yeah, I have all participants selected.
Okay, let me try this. Oh no, it seems like I need to grant access. I'm sorry, let me just try one more thing.
We can wait.
Security and privacy. I have a new computer.
Okay,
It
so
has
these are
very
your
strict
settings, not my
privacy settings. Huh? Okay,
yeah.
here.
These are your settings and not my settings, right? Because
yeah,
mine are
yes.
Okay.
Okay. Let me see if this works now. Here we go. You seeing that?
Yeah.
Okay.
Yes.
So this is just to illustrate what we're talking about when we're talking about 30 feet of vegetation. This is a group of some Norway spruce trees. And I'm showing some examples of evergreen trees that are commonly used in screening for landscaping purposes. And so this is in my yard, and this is just about exactly 30 feet, if not a little bit over 30 feet depth of vegetation. This is from the edge, 8 feet in, 16 feet. We're still not to one tree yet. These trees are definitely in the 20, 25 foot range width. This is 30 feet. So again, Norway spruces have a typical width, I believe, of at least in the range of 25 feet generally.
How old would you say that tree is?
I think these are about 25 years old. I don't know exactly. They're not
Okay.
full grown. This is underneath white pines on my neighbor's property, and they provide a nice buffer of their house. But the canopy of these trees is at 20 to 40 feet wide, and this is 16 feet, and it would be interfering with the boughs of the tree. So you'd have to cut off all the bottom limbs of the tree. I don't think you could fit a white pine in 16 feet of vegetation. So these are commonly used in screening arborvitae green giants. They have a typical width of 12 to 20 feet. Again, you probably couldn't fit this in 16 feet. You would run into issues when they reach maturity with them being too wide for that area. This is just for a comparison. This is an eastern red cedar, and it's exactly 16 feet wide. And also just for reference, because many of us are familiar with this type of shrub, Forsythia, mine has been very severely cut back by the highway department. It's still almost 12 feet wide, and these bushes commonly reach 12 feet. So this is just to illustrate as well that 8 feet of vegetation is not very much space to establish any kind of substantial evergreen screening. You could put something like this in that amount of space. This is a different variety of evergreen arborvitae, and there are other kinds of dwarf evergreens that might fit in an 8 foot wide space. So this is not meant to be a comprehensive review of landscaping, but I do want to point out that you have information, I mean, just based on a common understanding of evergreen tree species and what can fit in that amount of space, that I think it would be very challenging to have substantial screening and buffering in that amount of space. So to conclude, I would like to just say that we want to also emphasize that the ZBA's decision in this case could set a precedent for allowing paved areas, clearings, and other improvements or development in throughway buffer areas in other properties of the MSMU and gateway business districts that have this type of buffer, which would further undermine the intent to mitigate impacts from the transportation activities on the throughway. And we urge the ZBA to determine that the location of a 10-foot wide paved trail and associated clearing through the 30-foot MSMU buffer is contrary to this design standard. The planning board can still proceed with consideration of a waiver of that requirement if the applicant provides proof of hardship, or the applicant could propose an alternate route for the trail outside of the buffer. We note that there are an additional 20 feet of side yard requirement in the zone. It could be possible to put the trail right next to that buffer and stay out of it and still preserve its function. So we thank you again for your time, and I'll let you proceed.
Is there anyone else that would like to speak before Stacy gives a closing statement? Okay, I guess the floor is yours.
I see Amy with her hand up.
Okay.
I'd like to recognize that I think Ari was before me, but I have a very quick comment. That site is pretty damp, and in my experience, an arborvitae, particularly the pillar type arborvitae that you showed in the last slide, Ingrid, is ideal for that sort of environment. It's fast growing, good color, and likes damp. So if we are going to consider trees, Norway spruce is not the right tree for that location necessarily, but certainly there are plenty of trees that would provide a nice buffer. So I think Ari has something to say.
I have to be recognized by the chair.
Yes, please speak.
At the risk of offending Ingrid, I think Ingrid has stood in opposition to every single proposal we have made in the last 7.5 years. Pictures that you showed, Ingrid, were misleading. They were pictures taken in your yard, which is cleared space, of trees and shrubs, deciduous shrubs, in the case of the forsythia, as opposed to the non-deciduous, which I believe we had proposed. But also they were out in open space. And so a tree sitting in the middle of an open space has a look. Our property butts right up against the forest that flows down to the highway. And so when we plant trees, even in an 8-foot width against it, it's a completely different look. And even though it's separated by 10 or you say 14 feet across the road where the next row of plantings goes, it's a dense amount of planting fronting a very dense amount of planting, natural planting. So it's misleading to show a tree sitting there. This buffer, as we all know, was originally conceived as a concept which would preclude a development on my property from affecting my next door neighbor. And here, the next door neighbor hardly is objecting or in a position to object. The noise emanates from the next door neighbor. It doesn't emanate from us. So my suggestion to the board is to conceive of a non-deciduous planting row, 2 rows in parallel, designed to create a continuation of the forestation that exists off our property. It's a whole different thing than what Ingrid has depicted. It allows this kind of flexibility in a zoning code, which in this case provides flexibility, as we have seen from the building inspector's analysis. This kind of flexibility allows us to have both additional buffer and a bike path, which is something that a lot of people seem to care very deeply about. I hate to use the phrase of looking a gift horse in the mouth, but that is exactly how this feels. We are trying our best to give you what you need for the good of the town, for the good of the trail. We are providing something ample and substantial, and it will be a solid green sea all the way down to the highway. But somehow it's not perfect. Well, I would quote to you, Ingrid, the old statement by Voltaire, the philosopher, which is the perfect is the enemy of the good. This is good. Perfection is not something that any one of us are likely to achieve in life. So I would request that the board view this as achieving a meaningful impact and providing to the town and the region a meaningful benefit with a meaningful buffer. And that's it. Thank you for listening.
Thank you.
Len?
Are people allowed to weigh back in as Mr. Freilich just did?
You may speak, Kitty.
Okay, I just want to point out that we're very grateful to Mr. Freilich for offering a new connector trail, the Empire State Trail. And the original plan he submitted showed it through the parking lot, which would be an excellent, very safe place for it and would not require any disturbance of the existing buffer. That's it.
Thank you.
Len?
I can't see, I hear a voice, but I can't see a face.
May I respond to that?
Yes, you may.
The original plan, Ms. Brown, you're right. There were iterations in the planning process in which the bike path rode through the parking lot. And it was at the request of various municipal officials that it was relocated. They felt that it created safety issues and a variety of other issues, which I no longer remember. But it was at their request that the trail was moved to the side in order to provide a more safe and beautiful tour down to the off the corner where the safety issues exist. So, we're serving so many masters here in this process. And I don't know, the old iterations may have been better from one perspective, but clearly in the minds of municipal officials were far worse in others. So that's it.
Thank you.
Yes, Len. Now it's John.
John, you may speak, John.
Yes, I think we're starting to veer into discussions that are really more appropriately site plan discussions, which are not really ours. And I think I would like to just steer this back to the Zoning Board of Appeals to take this a step back away from this particular project, although this is where the question was raised. But we're being asked to consider things about the town zoning code, which is going to apply to the entire Gateway District. And for that reason, I feel really strongly that the merits of a possible design waiver are there to be discussed. But when it comes to the zoning code, it's very clear to me what was intended in the language of the gateway zoning, a 30-foot natural substantial vegetated buffer for the purposes that are well laid out there. And it's inconceivable to me that removing about half of that, making it not natural, not vegetated, cannot reasonably be expected to suit the purpose that it's intended for. So it's something I feel strongly about, and particularly in connection with its application beyond this particular project.
Okay, thank you, John. Stacy, I guess we're about at the point. Is there anyone else who would like to speak before Stacy? Because after Stacy is done, we will make a decision.
I don't see anyone else, Lynn.
Okay, thank you. Stacy, your closing argument, please.
Yes, first I'd like to go back to something that Ingrid had said about the ZBA having the authority to interpret the zoning code. I'm going to kind of defer this back to George, or you may want to speak to your own counsel in regards to this. I don't know that our zoning code has provisions for the ZBA to interpret the zoning code, so they may want to speak to that. I think they might want to just clarify that in regards to what you can do in that respect. And I think, let's see. I think, did I lose George? So, I could defer back to that because you're not here to interpret the zoning code. You're here to determine whether or not the determination I made was the correct determination. And as Ingrid has pointed out, the planning board, has the right to consider a waiver. That's all part of what I've already said. So I just don't really understand what she's asking you to do other than to, change what the code actually says. But, having said that, I would just like to say, thank you for listening to me. I trust that you've all read the January 6th letter that I sent clarifying my original interpretation. Simply put, there's nothing in the law that prohibits a trail within the required buffer. The buffer requirement is a design standard. The zoning law places the responsibility on the planning board to determine whether or not the design standard is met and what mitigation factors, if any, need to be added, or whether a waiver should be granted if an applicant cannot meet the design standards based upon the guidelines as written in the law. Although you've received several letters from the ENCB and the public stating various arguments regarding the importance of buffers, environmental studies and recommendations, including statements that speak to the chair of the ad hoc committee's intent of the law as it was proposed to the town board, I remind the board that this interpretation is based upon a specific question, and the answer to that question must be found in the law as it was adopted by the town board. So regardless of the intent of the committee, I must apply the actual law as it was adopted by the town board, and it's that law as adopted on which I must base my interpretation. Further, because zoning laws are in degradation of property rights, case law requires me to strictly construe the zoning law, and if the provisions of the zoning law are ambiguous, I must interpret it in favor of the property owner. I could sit before you and spend much time arguing about the relevances of much of the information that was given to you for consideration and why a 5 to 15 foot wide landscape buffer is all that's necessary to screen a visual impact in one part of the district, but nothing but a 30-foot wide buffer would be adequate to do so along the thruway boundary, or why a 30-foot buffer is required to block noise when a study offered by the appellant explains that a 5-foot wide area can provide an optimal noise buffer. I could do this, but I won't. I believe that the board has all it needs to determine whether I interpreted the code correctly. The aggrieved parties can certainly believe that the design standard does not currently say what it was meant, and that it should be revised to require that the entire MSMU buffer area be a vegetative buffer without any exemption, if that was the intent. It is certainly possible to revise the law so it contains the appropriate clear language. One such example of this is the zoning definition of yard required, which says that portion of the open area of a lot extending open and unobstructed from the ground upward along a lot line for a depth or width, and I won't read the rest of the definition, but that definition clearly says it needs to be open and unobstructed from the ground upward. So nothing can be within the required yard. So a petition to the town board to amend this law is the appropriate avenue for the ENCB to take. The aggrieved parties should not rely on the Zoning Board of Appeals to overturn an interpretation of the law as it's written to reflect what they believe should have been written. And I thank you for all your time, and I'll accept whatever decision this board makes in this matter.
Okay, any more discussion from Joe, Amy, Steve?
Nope.
Ready to make a motion, I think.
Okay. I would like to make a motion that routing the Empire State Trail through the MSMU buffer is not inconsistent to the design standards, and that we support the New Paltz building inspector determination letter.
I second it.
Seconded by Stephen.
Clause to that
Okay.
motion.
Amy?
I'd like to add a clause to that motion. Stacy mentioned that zoning laws should be interpreted strictly because they are in derogation of common law. Is that correct, Mr. Moriello?
I think she said they're in derogation of property rights.
Thank you. Derogation of property rights. I'd like to add that that clause to your motion, Len.
I would agree with adding that to amend that motion. Okay, we'll take a roll call vote.
Wait, what is the motion say now?
Wait, Len, I'm a little unclear as to what how that would read in the motion that you made.
Another clause, another whereas, that because zoning laws should be strictly interpreted in favor of the property owner because zoning laws are in derogation of property rights. Len?
Okay.
I'm familiar with that case. Okay, so Alana, do you have the motion in place?
I think so. I don't know if someone wants to read that in full. I feel like I just have it in pieces.
Okay. What would you like us to say?
Just say it out, in a full sentence, and I can take it down.
Yeah.
Okay.
Yeah, Len, maybe if you could recite your original motion.
Okay. I'll make a motion that routing the Empire State Trail through the MSMU buffer is not inconsistent to the design standard, and that the New Paltz ZBA support the building inspector determination letter. And then we'll add Amy.
And then after the word letter, because zoning laws are in derogation of property laws, property rights, the applicant should be allowed to have the interpretation that favors. Len, can you help me out here?
What maybe you want to be very clear. Len's motion talks about or said supporting the building inspectors. Maybe at this point,
I think we should
you'd
drop
want to
that.
clarify it and say that because zoning laws are in derogation of property rights, and based upon the building inspector's interpretation in this particular case, that the board find it determined that the building inspector's determination was correct. I think you need to do more than support it. I think you need to definitively state whether or not the board feels it was correct or not.
I would just like to say that I think that goes far beyond the question that's really in front of us here.
Whether the building inspector's interpretation was correct?
That's it. I don't.
Okay, would you like me to change that motion?
I just don't think adding anything to that is germane to what we're really doing here.
The reasoning behind it is that I want to point out that if the board continues to tell the owner how to site the bike path, we're in derogation of his rights, because we're going beyond the very limited decision that we're being asked to make.
No, we are here to make a determination on the building inspector's letter. The locations or any of the aspects of the trail, its location or anything, will simply be viewed by the planning board.
That's right.
I on this derogation of property rights, and Stacy had a quote that she just entered into the record, and I think it had to do with if there is any ambiguity in the statute, then the building inspector is obligated to resolve that ambiguity in favor of the property owner, based on the theory that zoning laws are in derogation of property rights. Is that it, Stacy, or can you find that to repeat it again?
Yes, that's
That, I
correct.
think, is the point, Amy, that you'd like to see in here, is that if there is any ambiguity,
right,
the building inspector's determination has resolved that properly in favor of the property owner, and that's why the board finds the building inspector's determination correct.
Thank you.
We're ready to vote. I'll vote aye. Steve
Aye.
Esposito,
Aye.
Amy? Amy?
We need a voice vote, Amy.
John?
No,
Okay, thank you all. Okay, next item on the agenda.
Thank you.
16. You're welcome.
Thank you.
16 Cedar Ridge Road. We now have discussion on that. Again, your camera's upside down. If you could spin it, please, Mariana.
How about now?
Okay, that's perfect. Thank you. Okay, this application before us is for a 10-foot fence with legal standards being allowed 6 feet in the side and 4 in the front.
Mhm.
Okay. We've had a public hearing. Board members, let's have some discussion on that, please. John, yes?
I would like to, since the applicant is still here, I would like to ask if she has pursued any other alternatives, such as a vegetation buffer, which would not require a variance.
I thought about vegetation buffer. However, it's not a large area, right? So in order to plant trees, and like, it's interesting that in the previous case there was a detailed discussion of various options, and there were certain things I looked into that as well. But basically, to provide really good vegetation buffer, I would really cut into my lawn, and also the ground generally, like, and the lawn. First, there are a few issues. First, it's fairly shaded. It's very silty and shaly land. Like, I'm having trouble, like, really, growing grass. Like, it's a lot of effort to do that. So just to really come up with vegetation that would receive enough sun and would grow, and like it just seemed like not really with regards to time and finances putting into that, and effectively blocking what really is an eyesore for me. I thought that was the best option, and in terms of what will look aesthetically pleasing to me, because I believe I have the right to have an aesthetically pleasing view on my property, and the mess in the background is that background. That's I have thought about it, but I believe this is the best alternative given the circumstances.
Thank you.
Okay. Joe?
Len, John's question is a good one. It just points up, the criteria regarding the variance. Like that was one of them. Is there an alternative means? And I think, typically you would go through those criteria with the applicant. If you don't have them, I do.
Give me two seconds. I've got it. Thank you.
And am I the only person here? I have the applicant upside down on my screen.
No, she's
I have
straight.
myself upside down.
She's upside down. Yeah.
But it's like you told me. Hold on. How about now?
No, you're up. Now you're good.
That's good.
That's what I thought, because
Not funny with me. You're upside down. That's okay. I've seen.
I don't know.
That's
Like
all right.
you all look fine to me, so. I don't
Okay.
know. Sorry about that. I don't know how that.
Okay. Any more discussion with regard to the application from any members on the board? No. Okay.
You had a hand up,
You got a hand up? I can't see anybody's hand.
Amy.
So
Okay, Amy.
my question is whether whether a 10-foot fence would cover the objectionable parts of your neighbor's property. Is that right?
That's the intent.
Yes, but could it be 7 feet, for instance?
As I described, I mean, I can invite you to my home.
I saw it, and it seemed.
Well, you actually haven't been inside of my home to really see.
Right.
Again, it's the issue of how the property is located downslope.
I saw
And if you saw the layout of my house, the open space, the kitchen, the living room, and given again the sheds that I think to me they're extremely aesthetically not pleasing, and I do not want to look at that. Like I basically, had construction guys up there in the lawn, standing up and trying to measure what would be that height to, cover that.
Thank you.
One more quick question, if I could.
Yes.
Has the neighbor in question here ever been found to actually be in violation of town code?
I don't know. That's the question for the.
Well, that would be my question. And I think there may have been some items that he did have in his yard back when Mark was working for the town and Mark was handling it. When I was most recently out there, although the applicant's yard could be categorized as messy, there's nothing in his yard that I can cite him for. Okay, he does not meet the definition of a junkyard. There is no garbage. Okay, again, like I tried to explain to people, many different times. One person's junk is someone else's,
Treasure.
So it's. I've been there. I've spoken with the owner. There's nothing that I can cite him there for. I have no objection to this application. I understand where she's coming from. I understand where the neighbors are coming from. But the next door property owner also has his rights as well.
Thank you.
Okay. Stacy, what's the probability of a fence of that height at 10 feet that she's asking for remaining stable with regard to some of the winds that we have come whipping through here, since the soils may not, I don't know how deep the posts are. Is there any specifications with regard to that?
Well, we'd probably have to check the depth of the posts. It will catch wind, but again, it's also somewhat protected. It's protected by her home, and it's also protected by the forest land that's there. So it's
Okay.
not like it's out in an open. It's not out in an open field.
I understand.
But it certainly can catch, wind forces.
Okay.
The way how I understand, and if you also, I can refer you to the photos, the risk, the only risk is in the situation is to me, given the downslope nature of the yard. And therefore, when working with my contractors and this, explaining to them what I want, they dug those holes fairly deep and put a lot of cement in it. So right now I have posts, right, still extending since the job is not complete, waiting for this variance application. Right now I have the fence constructed up to the permitted height. So the posts are already in there.
Stacy, can I ask you how many 10-foot fences we have that you know of in the town?
I really can't answer that question. I don't know that I have entertained a variance for a 10-foot high fence since I'm with the town.
Okay.
There is an illegal one up off the River to Ridge Trail that I've been made aware of. Someone took a photo of it from the trail, and they put a small section of fence up to give them some privacy out the back of their home.
Okay.
Walk the trail, I'm sure you've seen it. That looks to be probably 9-10 feet in height.
Okay.
But I don't know of any that I've permitted.
Can I ask a question for Lynn?
Sure, you may.
Or for Mr. Moriello, either one. Since a variance runs with the land, and since there's always the possibility that the temporary structures will be cleared away, would it be appropriate to phrase this application in terms of privacy needs rather than screening from junk?
Yeah, I don't think that the board really needs to talk about, or in its resolution, screening from any characterization of the next door neighbor. I think the applicant has made it clear that it's her privacy and visual privacy are the reasons why she has requested the variance. And I think any decision the board makes should be in line with the applicant's request with respect to the applicant's property, and not anything having to do with the neighboring adjoining property.
Thank you.
Right.
I'm used to this. I'm still new here.
Okay.
And I don't think it can, I don't know then that the board could condition the granting of the variance based upon what may happen to adjoining property. You can't say if these structures were to disappear on adjoining property, the applicant's variance would no longer be good for the applicant.
Of course.
We
Yes.
really can't do that.
Right.
And I can just remind the board that once the variance is granted, it must be exercised within 1 year. And if the fence were to go away for some reason, let's say she sells the house and someone else buys it and they take the fence down and the fence is not replaced within, I believe it's 1 year, Joe, the variance is no longer valid.
It's my understanding that's correct, Stacy.
It would run with the land unless the landowner decides that they no longer want to take advantage of the variance that was granted. It would then come to an end.
Right.
If they
Okay.
wanted to do it again, they'd have to come back again.
Yeah. Okay, you want me to go through the 5 questions?
Yeah.
These are questions to be asked of the applicant. Please answer yes or no. Whether an undesirable change will be produced by the character of the neighborhood or a detriment to nearby properties will be created by granting of this area variance.
No.
Whether the benefits sought by the applicant can be achieved by some method feasible for the applicant to pursue other than this area variance.
No.
Whether the requested area variance is substantial.
No.
Whether the proposed variance will have an adverse effect or impact on the physical or environmental conditions in the neighborhood or district.
No.
Whether the alleged difficulty was self-created, which consideration shall be relevant to the decision of the Zoning Board of Appeals, but shall not necessarily preclude the granting of the area variance.
No.
Okay, at this point in time, the board has discussion as to its thoughts and concerns with regard to the granting or the denial of this variance. I'd entertain discussion from any of the other members. John, Amy, Steve?
One thing quickly, my main concern is maintaining the integrity of the zoning code and taking these conditions very seriously. And I'm sympathetic to the applicant in a lot of ways. I'm a little bit, I put some weight on the fact that no neighbors came forth really objecting to this. On the other hand, I'm not completely convinced that a vegetation screening approach wouldn't be made to work with further effort.
But this is not my choice to have a vegetation. Like, I have a right to have a choice, okay, given the
That's
budget
correct.
and so on and so forth.
Okay. I have a concern with regard to if a variance for a 10-foot fence would be granted, it would be difficult if someone just wanted to put up a 10-foot fence. A precedent would be set, which will establish a standard. I have a concern with that. You are permitted to have a 6-foot and a 4% and a 10-foot fence over the normal level increase. That is substantial. I disagree with your answer, letter C. I believe that the requested area variance is substantial. Are there any comments from any of the other board members?
Then, in considering those 5 questions,
Yes.
you're supposed to take them into account, but they're not determinative. You don't have to answer no to all 5 questions, right?
No, they can answer as whatever they feel is appropriate.
Right,
Those
but
answers.
they could receive a variance even if not, if the answers were not invariably no.
That's correct. You could or you could not. That's up to the decision of the members. That's why we have a 5-member board, so that decisions would not essentially be made by one person.
But essentially, those 5 criteria are, you create a balancing test for the Zoning Board of Appeals to apply.
And the balance would be the benefit to the homeowner balanced against the detriment to the neighborhood. Is that right?
But that's not just the neighborhood, Amy. That's the entire community.
Thank you.
You know, the 10-foot fence is not just specifically would be in the Cedar Ridge area, in all of the districts throughout the town of New Paltz. Okay.
Len,
yeah.
I'd just like to add this. And I understand and share your concern for precedent, as the Zoning Board of Appeals always is. And, you know, and you have to be concerned as to whether or not this opens the door to anybody who comes in and just wants a 10-foot fence. There has been, I think, a fair amount of discussion regarding the elevation issue between these two properties. And that was raised to support the necessity for the 10-foot fence in this particular case. Other applicants in other areas and other properties around town may not be able to fall within that same category, if you will, regarding elevation and the need for the 10-foot screening fence. Each application has to turn on its own merit. This one, again, I just remind you, the board, that there was considerable discussion about the difference in elevation here, which is what necessitated this particular request at this particular property.
Well, let me ask you, is there more than one way to skin a cat?
Well,
And I guess my thought is, if the soil base was raised 4 feet at a natural and even grade,
I'm sorry,
then
what base?
at the present ground level, if soil was brought in and raised,
There's
the
not possible.
It's right next to her house. It's right
Correct.
next to her house,
Thank
so
you, Amy.
It would.
I understand that, but this is just a thought, you know.
Yeah, I can supply more photos. It's not practical, and given
No,
the
I don't
water
need-
runoff issue.
I've seen it. I've seen the property. I've been there.
Okay.
Okay.
So Lynn, your question really goes to the issue of whether the benefit sought can be achieved by some other method.
That's where I was directed. Thank you, Joe.
Feasible for the applicant to pursue other than the area variance. For the applicant, that's really the issue that Mr. Losa's question goes to. Is there some method, and Mr. Gatto's question as well about a vegetative fence that can be any height. Of any of those, are there some, can the benefit be achieved by some other method feasible for you to pursue other than this 10-foot fence variance?
If this is the question for, I guess you're asking me, I do not see a practical way at this point, given the constraints of my property, given the budget constraints, given the soil conditions, given the landscaping. I do not see it as a practical way.
Okay.
I do plan to perhaps plant just things that would be decorative to maybe some vines or flowers in front of fence, so that it doesn't look like a wall and it's natural. But obviously, if I just plant just that, that wouldn't provide the privacy. And again, it is my privacy that I'm defending, and it's coming at a high cost. I understand your point, guys, that you sticking to the code. You really don't want to set a precedent with things. People will take advantage of something like that. And but I would like you to really understand my concerns and how upset I am about this situation. And I'm a good citizen here. I'm paying my taxes and contributing to the community. I'm a member of climbing community, supporting Mohonk Preserve. I understand the issue was the code and how you don't want to push it. I understand, but I'm a person here and I live with the consequences of the decisions.
Okay, thank you.
The other issue that I think makes or could possibly make this different from others is also that the immediate joining neighbor on the record favored the application and the granting of the variance, which is something that you don't often see with variance requests. in the past or in the future.
Hmm.
Interesting, kind of interesting in that regard, but the immediate neighbor supported the application, as did other neighbors.
Okay, any member of the board care to make a motion? John, Amy, Steve?
All right, I move that the requested variance be granted.
I second.
All those in favor signify by aye.
Aye.
All right.
Aye.
Nay?
Stephen, did you
Steve?
vote?
I can't, you guys are breaking up. It must be me. How high is the fence gonna be?
10 feet.
No. I'm good with 6 feet. I can understand putting a berm down and then putting a fence on top of it. I'd like to put a 10-foot fence between me and my neighbor because his dog barks all night and he's got cars in his yard. I'm not putting up a 10-foot fence. I'm not doing nothing. I'm feeling eventually they'll move the cars or sell them. I'm dealing with 6 cars and I'm not putting up a fence, but it's a shared driveway. That's what I bought. That's what I moved into. A 10-foot fence, I understand how she feels. I've driven past several times. The neighbor wants it. The guy that was there, he spoke about it. He's very uptight about people throwing him under the bus. A 10-foot fence, I would do a 6-foot fence. I understand she wants to do flowers and bushes and shrubs. What if he gets his building up? The stuff that's out of his building, is it going to go inside the building? Is it building materials? Is the trailer registered on the road? Is it inspected, the trailer? Is it a commercial trailer for a business? Is it a trailer that's just to put stuff in? You know, he got thrown under the bus because he's doing a shed.
Oh, no.
A 10-foot fence.
Okay.
Everybody's going to want a 10-foot fence. And then what are you going to say? Oh, well, the house on Cedar Ridge Road has a 10-foot. Why can't I have a 10-foot fence?
Oh,
I'd like to put a 20-foot fence on my property between me and my neighbor to the south of me. I'd like to put a berm up.
Were you able to hear?
We have a split vote.
Sorry, I got kicked out for a moment. I think my connection was weak. I think I noticed the comment from Steve. I think that I think
I'm getting bits and pieces of this tonight.
Okay. At this point in time, we are done voting.
If you're done voting, if I understood the vote, it was 2 in favor and 2 opposed.
Correct.
To the granting of the variance.
Correct.
Okay. A tie, as a matter of law, a tie is a denial of the variance.
What if there's a member that's absent?
Because a majority vote to grant has not happened. So it would constitute a denial.
There's a member that's absent. I don't know if that changes anything.
No. Had a quorum.
No, we have a quorum. And this is why, just as a note to all members, this is why we do a quorum check. I realize Catherine had a situation, but it's imperative as a member of this board or any boards that you belong to, that everyone do their utmost to, I schedule my time around my February meeting. So I will make sure that I am there. And it's unfortunate that we don't have that last vote because it might have gone differently, but it didn't. Stacy, is it possible for her to come back for a 9-foot variance? I'm just throwing some stuff out there now.
I guess she could make a request for a different variance, even though, a similar variance has been denied. I don't know what the legally how that would go. Perhaps Joe can advise you better on that. I don't know if, because a vote's been taken, if there could be any discussion or any amendment to her application.
I don't think that.
Sorry, I missed that. So who's voted for, who's against? Like, I only missed like, I'm sorry, I missed most of it.
John and Amy voted for, and
Okay.
Stephen and I opposed it.
Based on the fact you're really concerned about this is the precedent, and that's your concern for the community.
That's my primary concern, yes.
I'd
So-
like, excuse me,
And very little concern for me appears, so.
excuse me, excuse me, if I can jump in here for a minute.
No, you may not. You may not. The public comment is done.
Well,
You
I
may
think
listen.
Mr. Esposito's.
Alana, mute it, please.
Can't do it. It's
okay.
Concluded by a vote.
Okay.
In answer to, a subsequent application by the applicant, I think would have to be entertained if it were made. Nothing precludes a new application from being made, other than maybe an application for the same relief, because essentially that would be a request for a re-argument, and there are restrictions on that for the board to be able to do.
Okay.
And what's the process? So basically the same process and additional fees to be paid. So effectively then 2 more meetings and how many more hundreds of dollars payable to the New Paltz? Is that the process?
Well, the process would have to start again with the new application. If you decided to do that.
Is it possible to waive the fee since we already have the,
Somebody has to pay Mr. Moriello. I would not recommend waiving the fee on, again, you start waiving fees and everybody else that's going to come in is going to ask for waiver of fees.
You can't waive the fees, only the town board would waive the fees, and I'm not so sure if the town board would waive those fees, and that would have to be a request from the applicant. I think we know the only route for Mariana to take at this point. Mariana, would I suggest that perhaps you and I can talk tomorrow about some options you may have?
Sure, that's fine. I mean, I'm just somewhat, I just want to express my disappointment and outrage that again, despite everything that you heard during the public meeting, despite my, very thorough documentation of everything that I'm, that I'm upset about, and even the issue where this barrier seems to make 2 parties that have had issues, me and Mr. Kakandis, that seems to be the barrier that makes, this improves the neighbors' relationship. That's was his letter for support, and despite that,
Mr. Moriello is asking to speak, Alana.
I think the board just focuses on
If
the code and giving very little consideration.
We've
to
made
the
a decision. I thank you for your comments, Mr. Moriello.
If we didn't allow Mr. Siegel, for instance, to put in anything additional following a vote, I don't think anybody should be allowed to put in anything more following the vote.
Okay.
Although
that
Stacy's suggestion to the applicant, I think, is a good one.
Okay. Thank you for your suggestion, Joe. Next item on the agenda is an area variance for 6 Oak Street. Mr. Stepanovich, are you there?
I am right here.
Good evening.
Good evening.
Could you please give a brief, Stacy? Do you have a question?
I just wanted to apologize to the board that I did not have time to prepare a memo on this application. So we can certainly, Mr. Barr can certainly, or Michael can go ahead with, his presentation, and then I can clarify anything for the board if they need it.
Okay, thank you. If you would, please, Michael.
Sure. So yeah, we live at 6 Oak Street, and as per the code, we should have 50 feet behind our house to the neighboring lot. We'd like to put a four-season sunroom off the back of the house. We have explored different areas around the house where it could potentially go. It's a 1,500 square foot house, so it's a nice size home, but not like extravagant. So there's not that many areas where you can put a sunroom, given where the septic is and where the well is. So really, we're looking for it's about a 5-foot 10-inch variance. We can get to like 44 feet from where the end of the sunroom would be to the neighbor. So that's really the request. And just so you know, that there is no real neighbor there. It's just woods. It's when I talk about the neighbor, it is to a vacant lot that's near us. So we're really surrounded by woods on almost all sides at this point. So that's the high level request. I don't know if you want me to go into more detail or David, if there's anything to add from your perspective.
No, it appears as though it's a rear yard setback issue, and that's what we will be discussing. Stacy, you have something to say? Oh, can't hear you.
I have no objection to this application. Yeah, he's looking for a 5'8" variance into a 50-foot setback requirement. He does own the property to the, let's see, this didn't quite print out very well. He does own the property to the east in the rear. Does it come all the way across? I don't think it comes all the way across.
No, the property, no. The back lot that would border where this is, I don't own that. I do own the other side, but it's probably not as relevant to this discussion.
The variance, sorry, I'm the architect, David Barr. The variance is 5'10", not 5'8". The property line is at a slight angle with the back of the house. So on one side, we're at 5'8", on the other, we're at 5'10".
Yes, I see that now. Thank you.
Yep.
Okay.
I would recommend, a little, if the board is inclined to approve this application, I would recommend a little bit more than the requested 5'10", just for construction error.
Mm-hmm.
Okay. So that should be defined in the application, or is it defined in the application?
We have 5'10" in the application.
How much did they ask for in the application?
5'10".
5'10". We asked for 5'10" because I think as it slopes, that was the larger side. So we went with the larger side.
Yeah, my concern is just in construction, if something ended up, an inch or two bigger or whatever, and then all of a sudden we find on a survey map that it's, 6 foot. Okay, we don't have a violation of the variance. That was my only point. When getting into inches, it's a little,
I mean, we'd be happy if we go to 6 inches versus 5'10", and that makes things cleaner and easier. Happy to do so.
You go to 7 feet, you're safe for sure.
That would make me a lot more comfortable.
Yes. I would advise that.
Okay.
I would suggest that.
No
yeah, we were trying to keep it as close to 10% as possible over what was required. So yeah, we go to.
Happy to take your recommendation.
Okay. So what we need to do now is to set a public hearing for the February 10th meeting.
Okay.
Motion to set a public hearing for 6th Street for a area variance of 7 feet for the February. Second, someone?
Yes, second.
Thank you. All those in favor by aye?
Aye.
Aye.
Okay. Michael, are you still there?
Yes, I am.
Okay. You'll need to speak to or get in contact with Alana, and she'll provide you with the information that you need to let your surrounding neighbors know.
Okay.
And then again, once all that has been completed, there's an affidavit that you'll sign and bring into her that she will tell us that information has been done. And if all goes well, we'll make a decision at the February 10th meeting.
Fantastic. Thank you very much.
Okay, thank you.
All right.
Thank you.
Good night, everyone.
Have a good night.
Take care. Bye.
Now, Mr. Rotolo is no longer on the agenda since the public hearing never came to be. And is there any discussion that any board members have at this particular point in time that they'd like to bring to the table? Joe? Stacy? No?
In regards to,
Anything?
oh,
Amy?
No, I'm okay.
All right. John?
Nope.
Okay, so I guess we all say good night. We'll entertain a motion to close. Joe? Oh, can't hear you. I'm sorry.
Alana, you're still there, right?
Yes.
Okay. The board did make a determination with respect to one of the applications here. It was the appeal
Yeah.
from the building inspector's determination.
Mhm.
So you will need to file the minutes of tonight. I would suggest you file the minutes of tonight's meeting that contains that determination with town clerk, which needs to be done within 5 business days.
Okay, there's no formal resolution or anything? It's just the minutes?
It was made in the form of a resolution as part of the minutes, so I would file the minutes.
Okay.
Like you did in the other case.
Okay.
There was also another determination that was made tonight,
Yeah,
which was the denial of the fence variance
yeah.
by virtue of the vote. So when you file the minutes, that will cover that determination as well.
Okay, no one needs to sign that or anything?
I'm sorry?
No one needs to sign that or anything?
No, you're gonna file the minutes with the town clerk.
Okay, yeah, that's no problem. I'm just like, for the village, anytime there's a decision, there's a resolution, and I need the chair to sign it, so I'm making sure that doesn't need to happen here.
Yeah, they generally haven't done it. I think in the last one that we did, I added a signature line for
Yeah,
you as the secretary, just to demonstrate that they were indeed submitted by and filed by you. So you can do that at the end of the minutes like we did in the other one.
yeah, whatever.
may I? On the back of the application,
Yeah.
okay, there is a spot that says action taken.
Yeah.
Side withdrawn, signed by the chairperson and dated.
Yeah.
It is good practice to complete that on the application, especially, in the future when we go back and we look at something.
Yeah.
Joe's position is that you have to file with the town clerk. The town clerk should give you back a stamped copy that says received by her. So
Yeah.
you have a record that you have actually filed it with them. And
Okay.
would also like a copy of that as well.
I've got the signed copy.
Okay.
Do you want me to drop that off?
Yeah, you can drop it off. I'll be there tomorrow.
Okay, I will do that.
Okay.
That needn't be filed with the clerk. That just goes to the file.
Yeah, okay. Thank you. Entertain a motion to close the meeting.
So move.
Thank you, John. All those in favor signify by aye.
Aye.
Aye. Good night to all. Thank you
Night,
for
Ray.
coming. We'll
Night,
see you
everyone.
again on February 10th, unless we meet you in ShopRite. All right. Have
I
a good
hope
night.
we recognize each other.
Yeah.
Now with masks on anyway.